Yeah. Okay, we apologize. The break is late. So it's coming. So maybe sneak out while Judge Farr is not looking. But there's supposed to be cookies or brownies or something that's coming. So we apologize for that. It was supposed to be here 20 minutes ago. Marlise has a quick announcement, and then I will introduce Judge Farr.
Just as a follow-up on the question and discussion we had about HB 227, that does go into effect next week, and it will be applicable to all open cases. So from next week moving forward, any case that's open, and of course anything filed in the future, that will be applicable to as it's a procedure. It doesn't change the elements as the esteemed Mr. Van Dyke included in his comment. So just be aware of that. It goes into effect.
Okay, thanks, Marlise. Okay, Judge Farr is going to talk to us about status of the courts. So hopefully I'll have some good questions for him. I will be out in the audience with the microphone. But Judge Paul Farr has been a member of the Utah Bar for 21 years, has a degree in criminal justice from Weber State and a law degree from BYU. After several years in private practice, mostly civil litigation, Judge Farr was appointed as a Justice Court judge where he has been serving for the last 11 years. He currently serves in Sandy, Herriman, and Alta. Judge Farr has been serving as a member of the Utah Judicial Council for the past 5 years and is currently serving on the Council's Management Committee. And it's in that latter capacity that he is here today just to talk to us about what is going on. So like I said, pepper him with questions in addition to the material he's going to have, and we'll turn it over to Judge Farr.
Well, thank you for the invitation to speak with you. I would like this to be a discussion as much as possible. And if you have questions as we go, please raise your hand, interrupt, and we'll answer those as we go. If you'd have told me last year that in April of 2021 we'd still be having this discussion on court's response to COVID, I'd not be real happy about that. If we have this need next year in 2022, I'm not going to be available. I will be on a beach someplace else. But it has been a long year for many of you, I know, as well as us at the courts. A lot of learning that's come from it as well, and hopefully things that we're doing better. I do want to give a basic background, and I know we did this once before, but I know some may not have been present at that, but I'd like you to know who and where these decisions are coming from. So the judiciary is, of course, governed by two bodies in Utah, the Supreme Court that everybody's familiar with, and also the Judicial Council. And before I became a judge, I knew the Judicial Council was there. I didn't know a whole lot about its detail. But it's made up of members of each court level, chaired by the Chief Justice. And if you think about it, the Supreme Court is responsible for stuff that goes on in the courtroom. The Judicial Council is responsible for the stuff that goes on outside the courtroom. So rules of judicial administration, judicial performance, court facilities, support services, staff levels, all that type of thing are in the Judicial Council's bailiwick. The council's members, each judge serves on a subcommittee. There are 4 subcommittees. They include legislative liaison, of course, deals with legislative issues, budget and finance, policy and planning. That's where the rules of rules of judicial administration are dealt with, and then the management committee. And the management committee tackles kind of the executive level issues. And that is where the COVID response has kind of been placed, is with the management committee. Now, some things are clearly within the court's jurisdiction, some are clearly within the Judicial Council's jurisdiction. COVID is one of those things that kind of interconnects. Some things involve court rules and procedures, others are administrative, and so the court and the council have worked together for the response. But the day-to-day functions have basically been handled by the management committee. That committee is currently chaired or staffed with Chief Justice Durant, also Judge Shaughnessy from the 3rd District here, Judge Mark May, who's a juvenile court judge here, Judge Mortensen on the Court of Appeals, then myself. And that management committee, part of the reason I said I'll be on a beach if we have to do this again next year, we've had over 60 meetings over the last year. That's in addition to the Judicial Council meetings. And again, this is taking information, responding, crafting the court's response to COVID. Ultimately, what happened when COVID first hit is judges were making the best decisions they could individually about their court or the district. And different rules were being put in place, different procedures, and it quickly became apparent that we needed a unified response. And so the council and the Supreme Court issued an administrative order last year. That order has now been amended several times. The most recent one being just, let's see, it was April 19th is the most recent amendment. And there's really three levels of response that the courts have put out. The first is that administrative order that governs things generally. There's also a risk phase response plan. You can think of that as an operations manual for the courts statewide of what needs to happen during the pandemic. And then individual courts, so 180 something locations throughout the state, including district, juvenile, and justice courts. Each individual location had to prepare a pandemic response plan that complied with those other documents and submit that to the management committee for approval. And ultimately, it's those documents that have guided the pandemic response. You're all familiar that some of you may have had in-person hearings by now, depending on your location, where you're at, or if there was exigent circumstances. But for the most part, for the last year, it's been all virtual hearings through WebEx. Just to give you an idea, and this was an estimate based on some older numbers, somewhere around 300,000 hearings have now been held by WebEx in Utah's courts with about 800,000 participants. And this was from a system that, as you probably all know, we were doing very few virtual hearings, if any, before that. And so IT and staff and everybody really ramped it up so we could do that. Just as a side note, I think there's some huge benefit to that. I practiced here in Salt Lake. I still remember having to drive to St. George for scheduling conferences that took 5 minutes because the judge wouldn't allow telephone conferences. So that, I think, is one of the things that we've learned from and is a better practice now. So again, virtual hearings in all those courts throughout the state. I wanted to talk a little bit about the administrative order, some of the recent changes that have taken place, and also a new order and why it's in place. So again, I mentioned that on April 19th, the new administrative order was put into place. There was also an order on just a few days after that. I'm trying to grab the date here. Or excuse me, before that, April 13th. I don't know if you all would have seen this, deals strictly with masks. There is a separate order. It's one page, and it says, in fact, I'm going to skip the initial part and just read this. It is therefore ordered as follows. Court patrons and personnel must continue to wear masks in courthouses and other buildings managed by the courts, such as probation offices, consistent with the risk phase response plan adopted by the Management Committee of the Judicial Council. The mask mandate will continue until otherwise ordered or unless authorized in the risk phase response plan. Those are being posted at each court location and continue to apply to staff and participants. That obviously, as you're all aware, something that's become very politicized. The reason that the courts are doing that is because we're in a unique position to compel people's attendance. And that can include individuals that are at high risk, individuals that aren't comfortable being around other groups. And so because of that, we try to balance that concern with this, that everybody's safety along with constitutional rights. And one of the things we're doing is requiring masks to continue to be in use. That has created some confusion and upset. Patrons coming to the court wondering, the governor ended the mask mandate. Why do I have to continue to wear a mask? And it's for that reason. The most recent administrative order from April did make a couple of changes. One big one was regarding warrants, particularly in misdemeanors. There had been some restrictions over the past year regarding when and how warrants could be issued. That language has now been removed. The thought is we've been practicing in this environment for about a year now. Everybody should be fairly comfortable with it. Individuals know they have to come to court, even if it's virtual. And so warrants will be issued kind of like they were before. Again, we're asking that judges be soft with their approach and make sure that if individuals really can't join because of a connection issue, work with people, give them a grace period. But ultimately, warrants can be issued for people not appearing in court. The court's response, and the question everybody has, when will we be back in person in court? It is tied to the state's transmission index. So the courts have a color-coded system with red, yellow, and green. And again, that's tied to the transmission index. And so this, I don't know if everybody's familiar with it. It's published every week. Get on management committee. I'm thoroughly familiar with it. I get updates all the time. But when a when a county is designated as either in the moderate or high transmission index, that corresponds to red for our courts. So if your county is moderate or high, there are no in-person hearings under that red designation. Once a county moves to low, then that goes to the yellow designation for courts, and there can be in-person hearings in yellow. Still, safety precautions have to be put in place. Courts have to follow that pandemic response plan that was mentioned, but we can have in-person hearings. To give you an idea, this is the most recent transmission index from a few days ago. It is showing the only county that's currently high is Grand County. It's really high. And then the rest of the counties are kind of split half and half between low and moderate. Kind of as you can imagine, for the most part, the larger counties are still moderate. A lot of the less populated counties are low. So again, in those counties that are in low, the courts would be authorized to hold in-person hearings and operate under the yellow restrictions, assuming that they filed an appropriate pandemic response plan that's been approved by the management committee. The red, yellow, green chart is on the court's website. I also have a copy with me if anybody wants to see it or has any questions, but it just gives a little bit of detail as far as what is allowed under each of those colors. We're in a little bit of a flux right now. I'd like to say I have better answers as far as what's going to happen, but things are really in play. And that's because numbers are down. For the most part, vaccination numbers are very high. And so we see some changes. There's actually going to be a small group of the Judicial Council, some presiding judges. They're going to be meeting with professionals with the University of Utah and kind of reevaluating our process and what we need to do. But we continue to look to the public health officials, that includes the Center for Disease and Prevention, local health departments, state health department, and again, health officials from the University of Utah in setting our response. We are anticipating there will likely be changes over the next few weeks or months as we get this new information. But right now, I can't tell you exactly what that will look like or how soon that will happen. Ultimately, we're trying to balance, the constitutional rights of individuals and defendants with public safety. Again, recognizing that we have the unique responsibility and authority to compel people to come to court. Jury trials have been a huge focus of what we've been doing and still focus on. Some of you may know there's been a jury trial pilot project. It was authorized, rules put in place. That's happened in some locations in the district court, including here in Salt Lake County. The justice courts have actually just started that as well, some here in Salt Lake County. The court I'm in, Sandy, West Valley, Salt Lake City, we have just started participating. I think West Valley has had some jury trial dates. I think that most of the juries have resolved. I do know at the district court, did I hear all of them? Okay, so no jury trials for West Valley yet. And as far as I know, Salt Lake City has not had them yet. I am anticipating one in Sandy in May, or the later part of May. We'll see if that happens. As you all probably know, once you get a jury trial date, they all start falling off like crazy, whether they actually go forward or not. Just my court in Sandy, we have a backlog of about 25 jury trials. We'll see how many actually go forward. The district court had, at one point, there were approximately 200 to 220 individuals throughout the state that were being held because of the seriousness of the charges and potential risk to the community. So they were being held in jail pending trial, waiting jury trials. Once the jury trials started opening up and had that availability, it's greatly relieved that. But again, juries continue to be a focus. And once we talk to the health professionals, I think there may be some relaxing of that or those restrictions. Hopefully we'll be able to see some jury trials coming forward in the next few months without all of the restrictions. Again, the vaccination rate has really been a game changer for our decision making. It's really affected the transmission rates. and other numbers. So once we talk to those health officials, hopefully we can provide an updated administrative order and new proposals or plans going forward. And then, ultimately we're pretty excited to get back to work. I know you all have caseloads that have been affected and backlogs. As judges, we do as well. On the misdemeanor level, we've been able, just as an example in my court in Sandy, traffic cases we've been able to do by video for the most part. They're not backlogged at this point. Criminal bench trials are kind of a mixed bag depending on the type of case and the attorneys involved. We've had a lot of misdemeanor trials by video. Some go better than others, but ultimately we've made it work. There are also some attorneys that aren't comfortable doing that, and right now it's in the defense, it's their choice whether to go forward. A prosecutor can be forced to go forward with a misdemeanor bench trial. The defendant gets to choose. I think I have around 120 bench trials on criminal misdemeanors that are currently backlogged. Once the floodgates open, we'll see what we can do. A large majority of that is with one or two attorneys, public defenders that just don't feel comfortable. And I'm not saying that's a good or bad thing. There might be some advantages for a defense attorney to try to wait that out as well. And then again, jury trials, I've got about 25. I know Salt Lake City, West Valley have a large number that they're trying to wade through. So once things do open, I still anticipate realistically several months to a year to try to get things back to normal schedule. Hopefully we can do that as soon as possible. There's also been a lot of discussion about future plans. What have we learned? What are we going to do different going forward? And I'd actually like to hear input from you all if I could as well. But I think there's certainly been some benefits to the WebEx hearings. And I see that personally in a couple of places. One is defendants on minor charges. I don't know how many hearings I've had where I can see someone is still in their uniform and they're in a side off somewhere at their work location talking to me at an arraignment about their case. So it's making it so individuals don't have to miss work. Have individuals all the time from out of state. Had lots of discussions about time zones and how that works when you schedule court dates. You're actually an hour ago, make sure next time you're here on time. So again, individuals that can now participate and have access to the courts that didn't before. I think that's been very valuable. For defense attorneys, it's also been very valuable. Instead of an attorney having to travel around the county or other counties representing clients, they can sit in their office and schedule these pretrials just back to back. So it's much more efficient. I'm assuming that also means that the clients are probably getting charged less as well as benefits. As prosecutors, hopefully there's still some benefits. I know you all may not have as much, but do you have a comment? And again, I would love to hear benefits and what you all would like to see as we go forward.
On the prosecution side, I would like an option for certain witnesses that live out of state or somehow they've moved out of Utah and they're not able to come back to testify for our trial. I have this jury trial scheduled in May, and 1 out of 15 witnesses in my jury trial case has moved to California, and she asked me to pay her flight ticket and hotel room for her to be able to testify. And I have oral arguments next week, and my request to the judge is going to be to accommodate her to join via WebEx. I know the jury trial is in person, but I don't have budget to accommodate her otherwise to fly here and come and testify. I believe that will be very beneficial to some point, and I'm sure the defense attorney has to probably object to it or whatever. It depends on how they reason about that accommodation, but that would be something, depending on certain hearings, that we can have that option for the witnesses.
Yeah, thank you. That's a great point with those witnesses. And with all of these issues, of course, we're balancing confrontation clause, right, and rights that individuals have. One of the strange things or issues is a lot of the confrontation clause case law predates even video technology that would even allow this. It certainly predates pandemic. So how does that, how does that case law and those restrictions play with kind of this new world of remote hearings? Yeah, it's a great example. Another way that the technology can be used as a benefit. I give you another example. You know, my court in Alta, and it's kind of funny. I serve once a month. It's one of the smallest courts in the state. So I work in Sandy, which is one of the biggest, and then Alta, which is one of the smallest. I have court once a month. We'll have a handful of cases, sometimes one or two. I think the busiest calendar I've had recently is 8 individuals on my calendar. A lot of that is going to end up being parking tickets, because parking in Alta, right, is terrible. So everybody's parking all over the place. You get tickets. Every once in a while, I'll have a criminal case. When we would go to court, the only person that was actually in Alta was the town marshal. Everybody else traveled from here in the valley, and a lot of people from out of state. So, you know, judge is traveling, the clerk is traveling, the prosecutor's traveling, the defense is traveling, all up the canyon so we can go to court, which sits in a community center above the garage where they put snowplows. Okay, it's kind of crazy. So starting last year, we started doing remote hearings. Now, Alta has a little bit different clientele than, say, Sandy or Salt Lake City or others. People generally have at least a vehicle and cell phones, and they're able to participate, so it's worked really well. So for the last year, I have not even been to Alta in the court. Everything's been virtual, and it has worked fantastically for that. Other court locations, again, Sandy, Salt Lake City, where you have, you know, maybe a homeless population, people that don't have the financial means, it becomes much more difficult to participate. But again, there are absolutely some benefits for everybody to incorporate these remote hearings where it makes sense. Other input or thoughts on what you all have as what's been a benefit or even a detriment to these hearings? Yeah, back here.
Just input for when you know, WebEx is going to be appropriate for the future. In my opinion, is it should be automatic for obviously your hearings that aren't substantive, but if you have evidentiary hearings, I think if you're dealing with issues where the credibility of a witness is immaterial, those should be pretty automatic, that a witness can do it over WebEx. You know, so like preliminary hearings where credibility doesn't matter, or even at trial when it's like an expert witness or a witness that's necessary for foundation for other evidence. And then having a rule that allows the court on a case-by-case basis to allow virtual participation for other types of witnesses, I think makes sense. One area where it doesn't make sense is drug court, because the participant and the judge developing that relationship that's very vital to the success of a drug court doesn't happen over WebEx. It needs to happen in person. So I would strongly object to drug courts happening virtually in the future.
Yeah, and that makes a lot of sense. And I don't know that you'd have anybody disagree with you on that. I think we all recognize that that is critical to drug court. I saw a couple of other hands, and thank you for that input. Someone up here, just microphone's coming to you.
There you go, Cliff. Oh, no, it's for the people at home.
Judge, thanks for your time. I have a question about whether or not there may be a judicial counsel to solution to a situation that comes up in my work at the Salt Lake County DA's office handling bail bond exoneration matters. The statute says that if a surety locates a bail jumper out of state in custody and the surety is unable to bring that person before the court, then the surety gets its money back. That's a nutshell version. And in these hearings, there seems to be a fairly easy solution, which is you can bring them before the court because of the administrative orders. COVID's made it easier. And for some reason, surety's counsel are not energetically behind this, and they seem incapable of arranging for a person who's in custody in Wyoming to get in front of a computer for a WebEx hearing to appear in Utah without leaving custody. Now, having said all that, is there, I don't know how often this comes up in your court, but he gave me the microphone, so, you know. Is there something the judicial counsel can do to press the sureties and bail bond exoneration matters to bring out-of-state defendants who are in custody before Utah courts remotely using WebEx? Is that something that could rise to the level of an agenda item, or am I alone in the wilderness here?
It's certainly something that the council could look at. Ultimately, I think that would probably need to be a legislative solution if we're going to be forcing, I would assume. But it's certainly something that could be raised and put on an agenda. Maybe we could talk after and I could talk to you more about that, how to do that. I would tell you, there is a bail bond lobby. We don't really get lobbied at the Judicial Council level, but we certainly, anytime we try proposing that and it goes through legislation, we certainly run into that. And overall, I would say the bail bond lobby has been more effective than Judicial, or heard more loudly than the Judicial Council voice with some of these items. But yeah, and from a court's perspective, it would certainly be possible and easy enough to resolve it like that if we could just get it required. Yeah, thank you. Were there other? I thought I saw another hand. Maybe not. Okay. My personal thoughts going forward is there are definitely some things that I want to continue with WebEx. Again, pretrial conferences where parties are represented by counsel just seem to be the really low-hanging fruit, super easy. I think it makes it easier and more efficient for everybody. Attorneys seem to have figured out WebEx, whereas a lot of pro se individuals maybe struggle with that a little bit more, so it's super efficient. So I am definitely going to be utilizing that for pretrials. I also anticipate having arraignment calendars where that is available for individuals, again, out of state, at work, or for whatever reason can't make it to court. The one thing I don't want to do is I don't want to have a calendar that's mixed where I have some people coming in person and then some on video. That just becomes very difficult. So I'm anticipating maybe separate days or times with those calendars. Did you have a comment or question? Yeah.
One issue that I personally have encountered, I practice currently in front of a judge that handles all of our domestic violence cases in West Valley. We do our arraignments and address jail release agreements and requests for protective orders at that time. One issue that I know that we have encountered is defendants being served with those protective orders who either provide a bad email address or fail to show up at the courthouse afterward, and we're kind of in this limbo where a JRA has been lifted and a PO has been ordered but hasn't been served. Do you see a workaround for that if you're going to conduct specifically domestic violence cases or domestic violence arraignments? Do you have an idea for a solution on that issue?
It's a great question and an important issue, and I have no solution for it. We're stuck in the same thing, and you'll see these individuals at arraignment. I do know that some judges actually treat that as the exigent circumstance that requires an in-person. So some judges at the arraignment are saying, I'm issuing a pretrial protective order. You need to appear at the court at this time to receive that. And that is one workaround. The issue becomes, well, what if they don't and you don't hear from them again? We have been emailing and mailing protective orders, telling people at the arraignment this is being imposed. And I suppose there could potentially be a challenge at some point if somebody says, oh, I wasn't actually served with it. But that, again, that's the kind of the best we can do at this point. Even the exigent, under the administrative order, an exigent circumstance case that requires an in-person hearing, you have to get the presiding judge's approval to do that. In West Valley, that's easy. You can walk next door, right? But for the rest of us, it makes it difficult to even get that permission in a timely manner to schedule that. So, yeah, unfortunately, there's not a great workaround. It's another one of these areas where I think the rules haven't quite caught up with modern technology and our processes, and hopefully that's one of the things that we can address. Anything else with that? Okay. Additional areas where I think it works and it doesn't. I don't know about all of you. I'm sure in West Valley you get this, but interpreters under the current WebEx platform, dealing with cases with interpreters is extremely frustrating as a judge. We have some pretty experienced and qualified interpreters speaking Spanish, and so that works better than some, but especially when you get some of these weird languages and someone is not experienced, it's a nightmare trying to get through a hearing. And so hopefully, and early on, the IT department, the administrative office of the courts went to WebEx. And I remember we approved that, and there were some really good reasons. There was security issues. For those of you that are familiar with Zoom and WebEx, Zoom seems to be so much easier and simpler, but we're stuck with WebEx. And I was actually involved in a meeting with simultaneous interpretation with Zoom, and it works so smoothly. And then get to WebEx at work, and it's just this disaster, people talking over each other and can't hear. So that's another thing I'd like to address. And I think going forward, if it's an interpreter matter, I would definitely want that to be in person as much as possible. Obviously, trials, jury trials, the current pilot project that's going on still has people in court. Jury selection happens virtually, but then the participants actually show up in court. It's distance, there's protections in place. We have struggled for a year to try to figure out how to make jury trials go forward. I don't think there's a way that we will ever be able to do remote jury trials. It's just not something that we can pass the constitutional requirements and still make work. Again, that's what I anticipate doing going forward. One of the questions we have is right now there are judges that are being kind of forced to do remote hearings because it's the only option. Once the pandemic is over and we're back to normal, I anticipate that there will be some judges that are really resistant to continue doing that. So that we are going to have ongoing discussions about, procedural rules, administrative rules, things like that, that could potentially even require a judge to allow remote hearings in some cases. I don't know that what the council's position would be. That's personally my feeling, is that we probably should, because again, I don't want to be forcing someone from, an attorney from Washington County to have to drive up to one of my conference, scheduling conference. I'd like to keep that available, and I would like to see all judges keep that available. So that'll be part of an ongoing discussion. There's actually a small work group that's just starting out, and I anticipate they'll reach out to others, including this group, to get additional input. But there will be a discussion about procedural rules, administrative rules going forward, and how that'll incorporate remote hearings. Any other input that anybody would like to give me? Again, this would be helpful on the management committee as I go back, so we can discuss, what works for you all with remote, what doesn't work.
So I have two questions. First of all, is there a way you can get all the judges to just do the same thing? And the second question, that's somewhat facetious, but that is one of the problems, right? Is you'll go into one courtroom, and I know this is going to be driven by judges' comfortability with technology, where you're comfortable with WebEx, and so you're going to continue to be doing remote hearings and live hearings, and you're going to have other judges who, if they can stop doing WebEx for a second, they're going to. I think the majority of all the practitioners is going to be, if we can still continue to do some remote and some live, we would all want that. And if there's a way for the Judicial Council or whoever needs to do that to try to make that so it's still a possibility despite judges not being comfortable with that technology, that would be fantastic.
Yeah, thank you. And again, that would be my personal goal as well, whether the council ultimately buys off on that. 'Cause there are ways it could be done, right? We could put rules in place that a party has a choice for certain types of hearings or certain types of things to appear remotely, which would require a judge to do that. Ultimately, whether the council would go that direction, I think there's a lot of members and a lot of judges that are leaning that way because we see the benefit. And again, ultimately, it's an access to justice issue, right? To allow as many people as possible to have access to the courts. So it makes a lot of sense. We have to balance that with, even as the Judicial Council, we can't interfere with a judge's, decision making and what they are able to do as a judge. So it's kind of a balance. Again, we'll be having discussions. It would be really nice if we could make all judges do the same thing. Unfortunately, we're all a little bit quirky and have some different things. In fact, I was actually I ate lunch today with somebody who was telling me that a federal judge here that still has their calendar on their desk that's about this big, and you can see him flipping through the pages to get to the calendar slots. So I know there are going to be some judges that are hesitant to go, again, all digital and remotely once they no longer have to. We'll see. Other questions? And if there's other questions that you have about what I've talked about, or even something else you just wanted to ask because I'm here, I'd be happy to answer that.
So I'll ask my second question. And again, I know this is a little bit facetious, but whatever you have. So up until now, defense attorneys have basically said, I don't want to do a jury trial because I want it to be in person. And now that we've actually started to do the pilot projects, every single one of those defense attorneys is going to turn around and say, wait a minute, my client's speedy trial rights were violated because of the order that came down from the Utah Supreme Court. So I don't know if there's any type of, again, it would be great if they could just issue an order from the Utah Supreme Court that said, look, this isn't a basis for a speedy trial violation. But do you have any templates or any advice or anything there going forward? Because this will be a motion that every single one of us is going to have to respond to, which is a speedy trial violation.
And that's a great question. We recognized early on as judges that was probably a motion that was going to be seen, in court. And we actually debated early on, should there be some type of a uniform response to that? And ultimately, the council and the court's decision was to let it take the natural process through litigation. The court can't give an advisory opinion. Council's not really in a position to do that, and we thought it would be better to let the motions be filed and rise up and be decided by judges and go through the judicial process. Actually, while I anticipated a lot of motions, and I'm sure some of you have seen those, I actually have not received that. I'll get an occasional person in court that says, what about my speedy trial rights? And I'll explain it. I have not had a serious motion challenging that yet. Have you all seen them? Or I'm not seeing a lot of hands or head nods. But again, I recognize it's an issue. You probably will. I still anticipate motions, but at least so far, really hasn't been an issue. And hopefully, once we have the option, the people can participate, or if they don't want to, and it's the defendant's choice, at that time, they're not going to have, a lot to argue one way or the other. Any other questions, comments? Okay. I thought there'd be a lot of discussion or comments. And again, if not even COVID, if you have something you wanted to ask about Judicial Council, how it works, how judges are responding, I'd be happy to answer any questions I can while I'm here. Well, this is good. I was half expecting stuff to be thrown at me, and since this wasn't virtual, it's a concern, so that's good. It's also nice to actually meet with people in person. I don't know about all of you, but I am so burned out with virtual hearings. And I tell people that I feel more like a air traffic controller now than a judge, because it's mostly dealing with how to help people actually enable their audio, and how to tell people to wait their turn and when to unmute. It's all that rather than actually making judge decisions these days. So again, nice to be with you all. And I see Mr. Drexel's here, so you can move on if you're done with me. Again, happy to answer any questions. If not, that's really kind of the updated information I want to provide.
Okay, well, thanks, Judge Farr. We appreciate you coming. Apologize on the break. Apparently, the kitchen did not get our order. They say the cookies are in the oven. So, Mike, you're going to have to talk until the cookies get here, and we'll send you home with warm cookies in your pocket. How's that? So, Mike Drexel's here from the Administrative Office of the Court. He just wanted to take a couple of minutes to talk about clean slate issues. And then he's also had already pre-planned. We're going to ask him to talk about HB 101, the forms, and so he's going to address that. So we'll turn it over to Mike.
Hi, everyone. My name is Mike Drexel, and I am the Assistant State Court Administrator at the Administrative Office of the Courts. I've been with the courts for about 3 years. And hello, John Gothard. Hello, Jamin Thomas. I used to work with these fine folks out in Uintah County in the Uintah County Attorney's Office for about a decade. I was a prosecutor, started in justice court out there, and then went to district court, and ultimately towards the end of my time as a prosecutor, was primarily responsible for prosecuting the sex offenses against children out in Uintah County. And as strange as it sounds, I miss the work. I miss the direct interaction with, well, you all know why you do the work you do. I miss all of those reasons that you have for doing the work that you do. I'm not here to reminisce, though, about that. I want to thank Bob and the prosecution counsel for making a few of your minutes available to us so that we can give you an update on the automatic expungement work that the administrative office has been doing. So as you'll recall, in the 2019 session, House Bill 431 passed. It passed very late in the session, and it was a bill that was targeted towards creating automatic expungement procedures for certain types of offense, lower level offenses, or cases that resulted not in a conviction, but rather resulted in acquittal or dismissal with prejudice. And the legislature appropriated funding towards implementation, but far less than was necessary for the courts to do it all in one bite. So they gave us a delayed effective date of 1 year, which was last May. And they built in some language into House Bill 431 that says that reasonable efforts shall be made to automatically expunge based on available funding, to give us some latitude to develop this with the appropriation they were able to give us. And we've made some significant progress on implementing a solution that can identify cases that are eligible for expungement. As you might imagine, the most difficult part of this is actually identifying cases that were convictions that are eligible for automatic expungement, clean slate expungement. And we're working with an outside entity called Code for America to develop the logic that helps to identify what cases are eligible. Some of the challenges, right? Somebody's name is John Anderson, and one officer enters it as Jon S-O-N, Anderson, and another officer enters it as John S-E-N, as Anderson. Are these the same individual? It's really challenging because we don't always have unique biometric data that helps us say, oh yeah, they're the same person, just a different spelling, right? Or the date of birth is off by a year or a day. And so the logic to say, yes, this is the same person, so we count these cases against the person to see if they're eligible or not, has been really challenging. But we've made a lot of progress on identifying cases that are eligible because of acquittal or because of dismissal with prejudice. The reason I'm here to talk with you all, though, is because in all of these contexts, the bill anticipates, the law anticipates that you as prosecuting agencies will get some level of notice about what's going on. In the acquittal and dismissal context, that notice is geared towards letting you know that it has happened. And the statute is written saying, based on information available, the court shall notify the prosecuting agency when the expungement order enters. For clean slate cases, those that were a conviction that are eligible to be automatically expunged, the notification is a little bit different. And we're not to the point yet where this matters, but I'll tell you, it requires us to give notice to the prosecuting agency 35 days in advance of taking any action on actually expunging the case. And that gives you, in your office, an opportunity to file an objection. And the statute outlines 3 reasons why you may object. One is that you believe that there's out-of-state, some sort of pending criminal action, either in-state or out-of-state. One is that they didn't pay restitution. And the other, I can't remember off the top of my head, I'd have to look at it. It's in 77-40-114. And if you file an objection to the automatic expungement through an e-filing document, it will automatically kick that case out of the queue for being automatically expunged. We aren't to that point, though, yet. And it's going to be a year or more before that becomes relevant. What we are close to being able to implement, though, is the automatic expungement of the acquittal and dismissal cases. And we want to be able to provide notice to you all. We want to have information available to connect with you on. And so what we had determined to do, and I sent a memo around about this in October of 2019. Bob was nice enough to send it around. I appreciate that. Thank you. Didn't get feedback except for, I'm going to call one person out, Rob Van Dyke. Hi, Rob. He did provide feedback to the memo and said, this looks like it would work for our office. Let me tell you what we had proposed doing. Taking a single email address within each prosecuting agency and sending all of the expungement-related notices to that one email address. Why? The reason why is because a lot of these cases are old, especially when you consider the historical cases that go back in time. The prosecutor who's on that case, whose email address is tied to the case, may not even be in the office anymore, may not even be alive in some cases, right? And so what we end up with is email addresses that would be a dead end, and the prosecuting agency wouldn't get notice. In addition, because there are tens of thousands of cases that are, is that better?
Yeah, I got word that the audio is not working, so if you use that.
I can start at the beginning. Yeah. Because there are tens of thousands, and even in some instances, depending on how you count it with traffic cases, there's hundreds of thousands of cases that are potentially caught up in this process. To send emails to a random smattering of attorneys and you end up getting 5,000 emails is not a particularly helpful way to send notification. And so what we decided would work better, and part of what we were looking for feedback on in 2019 was an idea of sending all notices to one email address and not sending them individually, but sending them instead in an in an Excel file format, kind of a CVS or an Excel file, so that you can then sort the list, you can search the list. They're all consolidated together, and we would do that in batches. So every time we came to a point where we were ready to automatically expunge cases, you would get this notification that either these have been expunged in the acquittal and dismissal case, or these have been identified as eligible to be expunged, and now you have time to 35 days to object if you think there's a reason to oppose it. That seemed to make more sense to us, and so that's how we designed the system. So what I'm interested, hopefully, in your help with is within the prosecuting agency that you represent, having a conversation and saying, where do we want these notices to go? What makes sense? Does it go to this generic email address for the office? Does it go to this individual, not because they're the person who prosecuted the case, but because it's one place to coordinate it, right? And then we provided a memo as part of your meeting materials on this. And in that memo, there is a link to a Google form that we've created where you can go in and select your prosecuting entity, say West Valley City, say, Salt Lake County, whatever it is, and say, this is the email address that we would like you to use for these notices, and then the name of whoever submits it so we can follow through if there's any confusion and circle back around with you. If we can get email addresses from the approximately 200 and something prosecuting entities in the state in a timely manner, we can then plug that into our system, pre-populating that so that that is one more part checked off as we move towards implementation and turning this on. So hopefully that's something that works for you all. I'm certainly open to feedback. There's one more thing I want to tell you about this, though, and that is that the Supreme Court and its advisory committee on the rules of criminal procedure has been working on a rule of criminal procedure tied to automatic expungement. It's proposed Rule 42. And it was published for public comment at the end of January of this year, and it closed in mid-March. The committee won't meet again until mid-May to consider the comments that were received. We received 5 comments, and from my look at the 5 comments, none of them stood out as being from prosecutors. I might be wrong about that, but they didn't read like prosecutor feedback. So we don't have a lot of feedback from prosecutors to consider on whether this works. This is kind of spelled out in the rule, a single email address, and that each entity is responsible for keeping the court up to date on what email address to use. So it may be worth your time, with all the extra time you have, I'm sure, to look at the memo that I provided, to look at Rule 42. You could email me feedback if you'd like. My email address is in the memo, or you can call me on the phone, and then we can get that in front of the committee, even though the public comment period is closed. More than anything, being a former prosecutor, I want to see that this works well for you all. I don't want it to create additional friction. It's not our intention to make a process that's difficult or taxing. The legislature saddled us with a pretty big ask to do this, and I don't want to pass that along to you all. So with that, if there are any questions, I'm certainly open to questions. Otherwise, I can talk about HB 101 for a second. Cliff.
In the cases where restitution is owed, I'm thinking that most of the
Yes.
Why does the administrative process involve or require the Office of State Debt Collection to look through this?
I'll restate the question, yeah. I'll restate it as soon as, yeah, absolutely. So Cliff's question was, as it relates to cases that involve restitution, which is a lot of cases, unfortunately and fortunately, and because the prosecutor is at a disadvantaged position to know whether or not restitution has been paid in full, especially when those get transferred to the Office of State Debt Collection, shouldn't the process entail some feedback from the Office of State Debt Collection that in fact restitution has been satisfied or not? We've designed the system so that if the courts note that restitution had been ordered in the case, which we know when it's ordered, and if it has been sent to the Office of State Debt Collection or not, if there's any sense at all that there's restitution still owing, we mark it as ineligible. And that includes checking our records to see if this office has given us a satisfaction of judgment on the restitution in the court docket. So we're trying to be ultra conservative to make sure that there's never an automatic expungement of a case if there's any possibility that restitution hasn't been fully paid. Cliff, does that speak to your question?
It does. I don't like the answer.
Cliff didn't like my answer, but it did answer his question. Yeah, I mean, the question is why.
Here's a list of cases. Tell us if any of these cases involve. Sorry.
You're fine. You can restate your question, or I can. Go ahead.
I guess I'm looking for daylight in the process where the administrative office of the courts would not rely on administrative staff of the courts, but would rely on the Office of State Debt, whose mandate it is to take over responsibility for collection. Send them a list and say, you tell us if restitution is owing. That'd free up the work from people who are making assumptions. It's referred to state debt, but we don't know if it's been paid or not, and shift it to people who will absolutely know the answer and be able to obtain it quickly.
Yeah, I appreciate the feedback. I will let you know that there aren't going to be, at least on those sort of issues, human eyes looking at this. We are looking at our database. Did we send something to the Office of State Debt Collection on this? Was restitution ordered, yes or no? Did we send it to the Office of State Debt Collection, yes or no? We know those things concretely. Do we have a satisfaction of judgment from the office in the file, yes or no? From the Office of State Debt Collection. If the answer is yes on the first one, and we don't have any further information, then it's not eligible for automatic expungement. If the answer is yes on the first one and the second one, again, if we don't have a satisfaction, it's not eligible as well. So we're trying to be ultra careful there. And an individual can still pursue the typical expungement process that we're all familiar with that predated the clean slate expungement process. So hopefully that's helpful. Any other questions on this? Yes, Rob, all the way in the back. Bob's bringing Rob a mic. That rhymes.
One issue I deal with in expungements is when it's a dismissal that they're eligible to apply for expungement after 30 days. If it's a plea in abeyance that qualifies in the future as a qualifying conviction for enhancement purposes, we object to those expungements until the end of the period for qualifying conviction status. Is your system taking that into account, or do we need to be looking for that?
It is taking that into account. The statute takes that into account. In the definition of clean slate eligible in the legislation that was enacted in House Bill 431, it says that cases that are dismissed are eligible except for those that have a connection with a plea in abeyance, in which case they have to go the full eligibility amount of time, which I think is 7 years for a Class A, 5 years for Class B. I think that's the case. I know that's the case for the definition. I can't remember if that's the timeline for the years.
Okay, so there's a different standard for the automatic expungement, because under a normal expungement, you can apply 30 days after the plea in abeyance is dismissed?
It is a difference for automatic expungement. Okay. Yes, we didn't want to be automatically expunging things out from under prosecutors who may have a desire. I say the courts, the legislature had a conversation about that and didn't want to be pulling the rug out from under a possible prior that could be used to enhance future offenses. And this is the funnest topic. Any other comments or questions on this? Please do all that you can to provide an email address for your entity. One of the things that may be the unfortunate fallout if we don't have email addresses is, especially for acquittals and dismissals, is the statute says based on information available. And if we don't get information from you all and we don't have information available to send it to, those cases may be getting expunged and your office may not be knowing about it. So please take a close look at that. And if you have feedback on proposed Rule 42, contact me, let me know what that is, and I can pass it along to the committee on your behalf. Okay, real quick on House Bill 101. House Bill 101 was the bill that creates an obligation on attorneys, prosecutors and defense attorneys, as well as the courts, to make sure that an individual who, by a conviction, either through a plea or at trial, will become a firearm restricted person, that person acknowledge that they understand, my plea will make me firearm restricted. And you've already heard this in your legislative update, but just so we're all on the same page, that acknowledgement has to be signed both at the plea-based conviction type and at the trial-based conviction type. And so the courts worked to put together a form, and that form was submitted to the Judicial Council, a dual-purpose form. It could be used for the plea context and the trial context. It was put in front of the Judicial Council April 26th, so what was that, Tuesday? A few days ago, Monday. And they approved the form. It will be on the court's website. I'm going to provide a copy to Bob via email, and he can distribute it to all of you so that you can use that if you have a need. The defense attorneys carry a heavy role here, right, in advising their clients. Not everyone has a defense attorney. And so sometimes it's you as a prosecutor interacting directly with them. And the statute contemplates that some of these acknowledgments and information sharing happens at that level. So it may be useful to you to have access to this form. At the sentencing context, it's a little murky, but the court carries more of an obligation to make sure that that acknowledgement, the information is given and the acknowledgement made and the document signed. So look for that form in your email from Bob, and we'll also have it on our website if you ever need it in the future. Questions about that? All right, this is a good group. Thank you for letting me have a little bit of time today, and have a good one.
Thanks, Mike. Okay, so I got to look at this. We are back tomorrow morning at 8:30 with our case law update with John Nielsen and David Simpson. And as promised, the cookies are here. They're still warm. Put them in your pocket, and they'll be nice and warm on the way home. So thanks for everybody. Thanks to those of you that are home that stuck with us, and we'll see you in the morning.